Welcome to the Arc of Grace Harbor's workshop, your back to school roadmap. Learn how to navigate your students' special education needs for this school year and beyond with Vanessa Lewis from PAVE. We're here with Vanessa Lewis from PAVE. Thank you so much for joining us, Vanessa.
Okay, and thank you so much for having me. It's been a while. Last year, I believe my coworker Sherry came and presented information, but it's all the same information, but we have our different styles of presentation. And so this is about Section 504, but also too, information regarding the IEP will be incorporated as we get further into the presentation. I am a paid person, and I've been there for 25 years. And we're a nonprofit organization. We provide information and training and individual or one-on-one assistance and resources to families, agencies, those who need our support. We're not a legal firm or a legal agency, but we do provide information that is hopeful, that is helpful to the individuals, that they'll be able to see a way out or see a plan regarding their child's, special education services. And we do have other paid programs underneath the PAVE umbrella. We do have parent to parent. We have STOMP, which is our specialized training of military parents. They work primarily with the military families within state and outside of the state, across the nation and all the other military installations. But right now, a lot of their work has been done by the virtual because of the COVID and so forth. And so keep in mind, we're not here to take the place of any legal advice. And if that, you can get through an attorney if you need to have an attorney. But most times we hope that things work out favorably for the families. And a lot of times it depends on the community that you're in and how everybody works together, such as yourselves, to make sure some of the big issues are really resolved without, families feeling overwhelmed and feeling like they need to take some sort of action or feel like they have to accept what's being presented to them. So we appreciate what you do in Grace Harbor. Okay, so in reference to Section 504, it's the Rehabilitation Act of 1973. So it prevents discrimination based on disability in all federal programs and facilities. So when you're looking such as your libraries, your court buildings, school buildings that would fall under that, you cannot, discriminate based on the disability. It has to allow access. And so within this, it includes Section 504, in which you're looking at accommodations and so forth in benefits and protections from discrimination in agencies that receive federal money. So in this instance, we're talking about schools. So any of the federal, state buildings that receive federal funding, they have to allow access under Section 504 in ADA. So those that work for state agencies, they have disabilities, they have to make that access available. And so when you look at the law, it says no otherwise under Section 504 Rehabilitation Act of 1973, no otherwise qualified individual with a disability in the United States shall solely by reason of her or his disability be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. And so again, tonight we're talking about schools, but it covers every institutions that receive federal funds. So equality is not always justice, but when you look at the scenario here, this is equality and this is justice, and everybody's getting straight across the board what they need. Okay. So here it allows access into all parts of the school. So we're talking about classrooms, if school bus or transportation is needed, lunch, recess, PE, after school clubs, sports, and field trips. 504 covers all that. Our students have access to those activities with the supports that they need, especially when you're looking at field trips and there's certain individual support is needed for the student. And it's not necessary that the parent has to be the one to provide that support. I'll give you an example. You might have heard me share this before in reference to the young lady who had a bone condition. And so she couldn't be around a lot of people and couldn't be on the bus. So they had to provide a private bus for her to be able to access that field trip. If not, if she just bumped herself a little bit or bumped into someone, her bones are very fragile and they would break. And so, and after school, clubs, drama clubs, things like that, if there's assistance that's needed, that is something, the support needs to be provided so they can access that. And transportation can be provided under 504. So again, these are words from the Office of Civil Rights, and it tells you what agencies, entities that it covers. And I'm not going to spend a lot of time on that, but if you want a copy of this section right here, I can provide that to you, but I'm quite sure you're familiar with a lot of it. But one of the things I want to point out is down later. We'll get to it later. Never mind. Okay, so we're looking for students, how do students qualify for Section 504? And remember, under 504, it is also free appropriate public education. And so it's when students have a physical or mental impairment, or the impairment substantially limits one or more life activities. And it's almost like, when you're looking at this wording, when you're applying for Social Security or SSI for students who have disabilities. And then when you look at what qualifies as an impairment, you're looking at the physical disability that affects mobility, speech, toileting, other human functions, spina bifida, deafness, dwarfism, or loss of a limb are examples. And then when you go down to the next part, when you're looking at a mental or psychological disorder, such as intellectual disability, which you're looking at Down syndrome, a brain illness or injury, bipolar, traumatic brain injury, or specific learning disabilities such as dyslexia is one of those. And so major life activity includes the walking, the seeing, the hearing, speaking, breathing, learning, working, digesting, toileting, eating, sleeping, standing, reading, concentrating, thinking, communicating, lifting, all of those things. So I use different words. So they say a 504 committee, I say 504 team, but when you're looking at the evaluation, they might be looking at the grades of the students, teachers' reports, comments, recommendations. Your information, parents' information is important, and from other agencies, which would include medical reports as well too, because you have to remember that some of our students that have medical disabilities might not necessarily need the full, might not need an IEP. They might just need the accommodations, but that medical information still has to be there. You're looking at your test, aptitude test, achievement test, physical condition, social and cultural background. Then there's also the disciplinary records, attendance record, health records, adaptive behavior information. So all of those are considered as part of the evaluation. And if there is need to have, and it's not listed here, to have testing by the school psychologist, that can be requested as also well too. So you can request for the school psychologist to do testing under 504. And what role do we play in the 504 process? So they don't necessarily have to include the parents on the committee or the team, but most schools do. We go ahead and we provide the information. They have to make, sound decisions, educational decisions about our children's need for the appropriate education. Schools notify parents before a student is evaluated or placed on a 504 plan. And then you'll get a copy of the 504 plan after it's completed, but most times you're going to be a part of that meeting. It eliminates a lot of confusion anyhow. And then so once you request for an evaluation, the school refuses, then the school is going to provide you the procedural safeguards that are provided under special education. So those procedural safeguards they're going to give you anyways, because they're sufficient, they'll suffice. And you can go through that process of, disagreeing with their denial of evaluation. And always keep in mind that you do have a 504 compliance person at your district. So when you look at the student handbook, you'll be able to see who that person is. And most times it might be your special education director, or it could be a totally different person that is the 504 compliance person for the entire district. So it's not just for students, it's just for all the folks who might need, a plan or accommodation. So it's not just limited to our students that person does that work. So when you're looking at the difference between 504 and an IEP, individual education plan, so the 504 provides accommodations in general education, but it does not have the academic goals, benchmarks, or measurements. So in other words, we have the goals that are written out for our students that from this day to this day, the student is going to do this, that whole year goal. But you won't find that under 504. That's not required to put in a 504 plan. And there's no benchmarks or measurements. But regardless, our students have to make educational benefit under that 504 plan, period. So they have to make educational benefit still. And so and you'll be able to see that through the report cards, any teachers' comments, if those accommodations are not working. So again, 504 protects the access rights, regardless of whether students need special education or not. And then a 504 plan goes from birth until death. So in other words, once our students move out of high school and they're going to be going to some sort of, training, college, or what have you, then that's where the 504 plan will kick in, and they'll get, they'll before they exit high school, they should have a current evaluation. Even if they're going to be in school to age 21, they need a current evaluation, from special ed. And then that is what is used to help when they move into, a training, technical training, technical college, what have you. They'll get connected with the disability specialist. And then from there, they're able to create the accommodations the student will need. And that goes for older adults as well too, but in this instance, we're talking about high school students, but that's why 504 goes from birth until death. Okay, and again, so when you're looking at, are there any questions so far?
What determines whether a student is on an IEP or a 504 plan?
It has to adversely impact education. And so if it doesn't adversely impact education, then they'll just get a 504 plan, but it doesn't prevent the family from disagreeing with that, but it has to be an adverse impact. Okay. But the 504 can encompass more, but it still carries a lot of power. Right. They still have to make benefit. They have to make some sort of educational benefit.
Is the 504 the base component of the Civil Rights Act, and the IEP is a step beyond?
Reference to that 504 is civil rights, but at the same time, that most families will start off requesting for an IEP anyways. We're going to request for an IEP, and so if they don't meet the criteria under IEP, but there's still a disability that's there, they're going to refer them back to the 504 plan. Yeah, and so because when you're looking at, there's 14 qualifying categories for special ed, specifically for special ed, and then under 504, it can encompass a lot more in providing those accommodations, supports, and services. So I guess what I'm trying to say is that when you start off, again, most families start out requesting for an evaluation for special ed services. Right. And then if they don't qualify under most circumstances, they're going to qualify under a 504 if they understand their rights. And so the team will say, we'll do a 504 plan because there's some sort of health impairment or other condition there that, identifies the student as having a disability. Okay. But even then, families can still disagree if they still feel like the student needs to have the IEP. They'll still have that opportunity to disagree with that.
When my child, who is on an IEP, graduates, will his IEP convert into a 504 plan?
If he's going to be going to some sort of technical college, some sort of training program, yes. Because as I stated earlier, what you want to do is have the students should be evaluated before they graduate so they can have a current evaluation. And then from there, they're connected with the disability specialist at whatever training program that they're going to be going to, or technical college, or what have you. And from there, they start instituting or help write a plan for accommodations for the student. All right, so now we're going to go IEP versus 504. Okay, when we look at the type of law, special education is the Individuals with Disabilities Act, which is called IDEA. And then when you look at the Section 504, it's the Civil Rights Act, Rehabilitation Act of 1973. So the agencies that oversee that under the IEP, Department of Education, at our federal level, and then the Office of Civil Rights oversees that under Section 504. So requirements for eligibility: has a disability that meets the criteria under IDEA, significantly impacts, and I said adversely impacts, but either word is the same. It has to significantly impact educational performance and require specialized services. That's when you're looking at goals, objectives, related services, speech, language, those things that are attached to that. Now under 504, they have a disability that significantly impacts a major life function. And so we saw those earlier. Could be walking, whatever that list was in the earlier part, breathing, learning, all of that. So under IEP, what's included in that is specialized education services, accommodations, and related services. So those accommodations that you'll see in the IEP are what you would consider 504, but they just don't list it as that. But that's what that would be. And then under Section 504 plan, it's accommodations and modifications, but also too, that under Section 504, you don't have to qualify, and I might be going too fast, for special ed services to be able to have access to the related services. And one of those we talked about earlier was the transportation, and transportation is a related service. And then some of the other services underneath that would benefit a student to be able to benefit from the instruction. And so what happens with that, when those things are, determined that they might be needed, because 504 doesn't have any money underneath that, the school district has to provide it. And so then that's when you might find if the student is just under a 504 plan, that's when you might see them moving them more under an IEP. Okay, having them be evaluated for that. And then for age limits, the IEP is, goes through the 12th grade or through age 21, whenever the student graduates. And then under the 504 plan, there are no age limits. So for the IEP, where the plan is used, it's educationally to the 12th grade and does not transfer to college. And then we have some students that are on IEPs that go ahead and are able to start some of their technical college programs. They have the 10 credits and so forth, or maybe a college program, some sort of training program. And they can still do that as a high school student, even if they are special education, as long as they have those 10 credits. And so their IEP, they'll be working with the disability specialist, will work with the student, family, and the school, and then they can take whatever those programs are, as long as they meet that credit requirement. So when you look at the 504, it's used, school, work, and college. And then again, 504 plans will transfer to the college. Now, when it comes to the discipline, under IEPs, a manifestation meeting is held to determine if the discipline was a manifestation of the student's disability, and that has to be done by the 10th day of suspension. And if there's going to be a long-term suspension, they still have to provide educational services for that student after the 10th day. On the 11th day, the student still should be getting some kind of educational services, even if it means that they're not going to be returning to that building. So under 504, when you're looking at a manifestation determined meeting, again, to determine if the discipline was related to disability, again, by the 10th day of suspension, and it may require reevaluation, because when you're looking at a student under 504 and they're going, past 10 days, if there's some previous, even if there is emergency suspension, the student has been suspended before, and it looks like it's going to be up to 10 days, you're looking at a change of placement, and it's going to require reevaluation. So any questions under the discipline part that I just spoke of? This is just kind of a overall summary of the difference between IEP and 504.
So
Okay.
would a parent be able to request a manifestation determination, or is that something the school would automatically do?
Well, under 504, if families don't know, it's important for them to know that if the school doesn't do it, they might want to go ahead and request it, especially if they're looking at long-term suspension. And again, it would be a change of placement. Under the manifestation determination under an IEP, that when you start seeing, suspensions throughout, or removals from the classroom or what have you, where they might go to in-school suspension or out-of-school suspension, when you're looking at maybe 6 or 7 of those, you might want to go ahead and initiate a manifestation meeting anyhow.
Okay.
So that they can look to see if it is related to disability, how do we change the services, and what support may be needed, for the student to be able to stay in and not out of school, without them having to look for another placement. And again, when we're looking at disciplinary actions, students with disabilities can be disciplined, they can be suspended, but there are still processes that need to be followed in order for them to be disciplined where they're going to be out of school. They still have to follow that same process up there, the manifestation meeting. And then for students, when you're looking at IEPs, if a parent has already made a request for a student to be evaluated for special ed services, and if a discipline was to occur where they're looking at suspending the student for a long time, his or her protections would kick in right away, because they're already being evaluated for special ed, and they would have to expedite that evaluation before they could really do any real disciplinary actions. And so students' placements cannot be changed under the discipline rules without them following the rules. You can't just, move a student out. They have to follow all the rules that have been laid out. Okay, so students under 504, they're going to be in a general education class, again, unless the student is so disruptive in the regular classroom that the education of the other students is impacted, and the students' needs cannot be met in that environment. And so regular placement would not meet his or her needs, since they would have to look at another place for the student. This subsection or section, that's federal, so I don't know what those 2 S's mean. And that's the same thing under IEP. When you're looking at the procedures for establishing an educational placement, before they can exclude them from, being in a general education classroom, they have to make sure that the harmful, look at the environment and making sure that there are no harmful effects in that environment that's going to impact that student's learning environment. And so that's a particular WAC under under the Washington State Administrative Code for Special Education, and the procedures for establishing the educational setting is very important to look at. And it lists out ABC, what they need to consider before they say no, and they have to give it an opportunity to work no matter who it is. And there's some families that are already aware and feel more comfortable for their students not to be in a general ed setting, but to be placed in a more, protective environment. And that's understandable. But for the most part, all of our students start off in general education. And so again, the 504 plan is supposed to be a success in general education. And so, you've seen these are some of the common accommodations: sitting at the front of the class, teacher, being trained, extra time, quiet space, technology, and then also an allergen-free environment. And again, that's, when you're looking at that, you got to look at that environment to make sure that everything the student is going to be able to have success, and is going to, benefit from that instruction. So there's no retaliation when you're looking at this. District cannot intimidate or threaten or coerce or discriminate against individuals because they've decided to use their rights under Section 504, Title II, oppose, disability discrimination, or participate in a complaint process or hearing. And so the Office of Civil Rights, if there was to be a complaint process, you go to the Seattle office, and you go online, and families can fill out a complaint process there. But it's best to start, with your, go through the chain of command, starting with, when you're looking at 504, starting with your team. Most of the 504 building designees are your school counselors. And if there's no agreement there, then you would move up and have a meeting with your 504 compliance person for the district. And for the most part, it's really good to document the request in a very, nice way, thanking them always for what they've done and so forth. But there is still a problem, and we need, or we'd like to meet to, to further discuss, or something to that effect. And then just always bullet out what it is you want to talk about, so that there's no misunderstanding of what you're asking for. And oftentimes, and if we, and I know that we work well with some of the individual professionals that are working with our children, that are instructing them and so forth, but we want to make sure that it's clear of what we are saying. Because sometimes when it goes to a third party, not intentional, but it's not what we're saying. It's not what we're asking. It's not what we are addressing, and so forth. And the same in special education. We, suggest that you go through that process as well too, before you start going here, there, what have you. Because if you're not prepared for it, and somebody says, okay, well, let's go, we're ready, you're not ready, then, sometimes you'll fall apart because you're not ready to move forward. Let me see. So any questions on that so far? But also under the IEPs, there's, there's the new complaint process at OSPI level that families can, and it's written up much more friendlier, what have you, and you can do a complaint through the OSPI office.
To file a complaint, visit the OSPI website at www.k12.wa.us. From there, you'll go to Student Success, click on Special Education, and then Dispute Resolution. File a community complaint. From there, you're going to scroll down to, is there a form for filing a community complaint? Click there. Then click on the PDF in your language. Fill out the PDF and send it to the address shown.
Also, too, I think a good process is the facilitated IEP meeting that Sound Options does, and it's really good. It's a good meeting, and there's a neutral party, and everybody gets a chance to be heard, and it's different people at the table, but and to include those who are providing instruction to the student. And then once everybody's able to hear, families are able to hear, school is able to hear, they usually come out with a good solution. And that's a step before you're looking at mediation or some other process, but I feel that the facilitated IEP meeting process is a good process. I really do.
You can request facilitation for an IEP meeting through Sound Options Group. You can find more information on the OSPI website, again at www.k12.wa.us. From the home page, click Student Success, then Special Education, Dispute Resolution, Request Facilitation. From there, you can scroll down and find the contact information for Sound Options Group. You can reach them at 1-800-692-2540. Or if you're in Seattle, you can reach them at 206-842-2298. If you scroll down further, you can find more resources from Sound Options about the IEP facilitation process, including a very helpful brochure. Is a facilitated IEP meeting something you request if you feel that you're not being heard or you're getting pushback from the school district?
So what you would do is call Sound Options. Everybody, is connected with OSBI, and it's no cost. And what you would do is call, since it's a neutral request, Sound Options. You would contact Sound Options, and then you would share with them what the concern is, and then from there, Sound Options will call the school district and share with them what the concerns are. And then it's a voluntary process on both parties' sides. But most times the school district will go ahead and do the facilitated IEP meeting. If they don't, then what they will do is they're going to bring you back to a meeting to try to resolve it again at the building level. Keep in mind the facilitated IEP process is different from mediation.
Right.
It's an IEP meeting. And that just fairly came up. That's been fairly, maybe about the last, maybe 4 years that came out. And then the mediation was the one where it's just like all day. Usually the facilitated IEP meeting might take about 2 hours, no more than 4.
Here's a quick recommendation. Take someone with you to the IEP meeting. This could be a friend, a family member, a mentor, someone else who's listening and can hear what's being said at the meeting. This will help because sometimes people hear things differently, and sometimes different people will remember different parts of the meeting, or will have different input. On the flip side of that, you can ask excess staff members to leave an IEP meeting. If there are people who are not part of the child's immediate team or providing a related service, you can ask that they be excused from the meeting. Sometimes having too many people from a school staff can be intimidating for families, and it's your right to ask for excess people to leave.
Yeah, but you are right that you do take someone with you because, but also too, and this is one thing I learned today, that was shared with me from another area, is that there were 16 people at this meeting for this individual, for this family. And they didn't know any more than 7 of them. The family only recognized the actual team members. And then the other excess members were not members of the child's team. And so what I suggested to them is to, and it's been suggested through Northwest Justice or what have you, that to ask, for, if they are, providing a service or support to the student, then it's okay for them to be there, to identify what they're doing. But if they're not a part of the team, you can ask for them to be excused, because you got to remember that you have, that's your children's private information that's being shared. And so if they're, there as someone that is not working with the family or working with the student, it is okay to ask for them to be excused and just have the relevant team members or those that are actually going to be working with the family, because it can be very uncomfortable when you have 16, 20 people in the room that don't provide any direct service or support to your student.
Do students on a 504 plan have the right to high school transition services from age 18 to 21?
504, there's no transition process under 504. So there's no right to a transition. That's only under the IEP. But there is one thing where there's an independent assessment request that families could make under an IEP, that Ellen Chestnut from the Office of Civil Rights, that there can be something established where there's a possibility under Section 504 that an independent assessment could be paid for. But that you'd be looking at a different process for that. She didn't eliminate that.
Is it appropriate for a child with autism and anxiety to have flexible attendance on an IEP?
Use the word attendance, but if there's some scheduling where the student needs to, take a break or needs to, only be at school for a half a day and they could provide the services in a different setting for the rest of the day because of the autism and the anxiety, that can be done if that's what the parent wants. Because we have a number of students that, because of anxiety or some other condition, that they can only tolerate school for so long, and then they have to come home or take a break, and then some can come back. And we're keeping in mind that IEP is individualized to meet the student's needs. So I wouldn't use the word attendance, but if he needs to have that break or time, whether it's something that's set up in the school or something where he needs to come home, then the rest of his services can be provided at a different location or at a different time throughout the day, or he can return for that. But it's individualized, but it has to be written into the IEP. So this next one was, my son was denied evaluation with a recent diagnosis, a dyslexia diagnosis from Seattle Children's Hospital. School focused on his performance at school last year and didn't even take into account the scores the Children's Hospital provided. Some of his scores from last year are not even meeting Washington state standards. He also has Duchenne muscular dystrophy, a disease, again, where a high percentage of kids have learning issues. Is there anything I can do? Yes, and what should have happened is that the 3 years ago, Washington State OSPI has a screening tool to screen students for dyslexia. And I can send you that information for the family, but since she already has the diagnosis, because once they found out there was an indication of that, there was a possibility that the school was going to have to pay for an evaluation anyhow if the resources and services that they were implementing didn't allow the student to still continue, in learning, because students with dyslexia, that's a whole different type of instructional style. But there is a screening tool that all districts are supposed to be using in reference to students with dyslexia, whether they've been diagnosed or not. Well, if the school didn't do the evaluation, you can't ask for an IEE. And so what the parent would have to do, because the school has to do the evaluation first, is that this is where it might be where she might have to go up through the chain of command, submitting something in writing to the special ed director, to the team, and letting her know she's in disagreement with the evaluation, the denial of evaluation, and that she has this outside information that indicates the student, that doesn't indicate, it says the student has dyslexia. Some folks use dyslexia, others will use specific learning disabilities, but you'll find that the evaluations look the same. Just depends on the evaluation and what the evaluator themselves. And so she has that specific diagnosis. The school should have took that into consideration, because it's still considered a disability, and it's a medical diagnosis, because you're not necessarily can do that in the school unless at one point, a school psychologist that had the background could do certain testing or what have you in reference to that, but it's not being done. That was a letter from the educational department that was done in 2015 or earlier.
You can find out more about requesting an IEP evaluation, also known as making a referral for special education, on the OSPI website at www.k12.wa.us. Visit Home, then Student Success, then Special Education, then Guidance for Families, then Making a Referral for Special Education. You can download an optional sample form to assist you in submitting a request for an evaluation. You can also find more topics of interest at the bottom of the page.
And what I do is that what I tell, because I run across a lot of families, if they start it, I'll help them with it as a draft.
Right.
And they can go ahead and make their changes, because I don't want to cause any conflict between the students, the parent, the student, and the professionals that they're working with.
Right. Right.
But someone has to be the voice. Our children, we, the parents, are the voice for our children.
Right.
And there's nothing wrong with disagreeing. And some things can work, for a little bit longer. You can keep working at the table. And then other things you can't keep working at the table, because you see I don't want to use the word destruction, but you see the struggle of the child, and then they start, almost deteriorating, where they just don't want to function. And I'm not just talking about teenage kids, we're talking about, little children, that are first, second grade kindergartners that don't want to go to school because of their struggles.
Right. Okay.
And then in reference to the last question, the student is going, from coming out of birth to 3 services, and will be starting Part B. And so basically, such as what we're doing tonight as the being a beginner guidance, is to get familiar with your rights and just, watch the progress that the student is making off of the IEP that's being presented. And just notice, any teacher's comments or concern. And you don't have to jump on them all at once, but, somewhere in the middle, before school gets out, you can address those, or before the first reporting period comes up for the progress reports for our students on IEPs, waiting for that first reporting period. And so those should come out, as often as you get, a report card. So some school districts only have report cards for twice a year. Other school districts are 3 times a year. And so our district is 3 times a year. So the first reporting period should be coming out between end of October into November. And then you look at that grid that shows progress not met, still emerging, or, there's like 4 areas on there. And that's part of your information to support whether something is working or not. And if they're not making just a little bit of progress, and that you need to have some sort of meeting to look at what can be changed, even at this young age.
Okay.
So it is important, yes, and I stress that a lot. And some of them do have them, and and I know that life is full. Everybody's life is full, and that we have to, take care of our families first and foremost, especially when we have children that have high needs, and then you can look at the rest of the stuff. But when you get a chance and you feel comfortable, start looking at it, because it's important.
If a parent requests an IEP meeting, can a school deny the request?
Not supposed to. Because the IEP, just like the school can call an IEP meeting, the parents can too. The sample letter, just go ahead and submit it in writing if they're still waiting for that meeting after 2 weeks goes by, a month goes by, and it's just between her or him asking the teacher. You want to reiterate that in writing so that you don't miss that time.
Can a student that's on an IEP or 504 plan be disciplined for behaviors that are part of their IEP or 504 plan?
Our students can be disciplined, but they can't be disciplined for more than 10 days. And so when you're looking at 504, and if they're looking at excluding them, and tell the parents every time they go pick them up, that's an exclusion. That's considered a suspension. If they're not going to initiate the meeting, they can initiate the meeting and request for that manifestation, because we're reaching 10 days, or it's 10 days. After 10 days, after the 11th day under IEP, they have to have something in place.
Okay.
Under 504, it's a change of placement. What the placement looks like, we don't know. But the disability has to be the discipline has to be related to the disability. If it's not related to the disability, then they can be disciplined the same as non-disabled students. So when you talk about a behavioral 504 plan, you want to look at it very clearly to make sure to see what accommodations are there. And if the student is being, sent home on several occasions, then that's when you're looking at that there is adverse impact. That's when you're looking at doing an IEP. But just keep in mind when you're looking at IEPs, when you're looking at the 7th or 8th suspension, you might want to move forward with the manifestation meeting anyhow. And make sure that those behaviors are documented as, the discipline is documented as related to the disability.
Is the 13.5% cap on special education funding a determining factor for whether a student will be placed on a 504 plan versus an IEP? There's a particular concern that this could impact transition services, as students on 504 plans do not receive transition services.
And those are decisions that sometimes parents make, in reference to how they want to go address the IEP versus the 504, because a lot of folks don't want that stigma on their children. They think that special ed is a place and they don't recognize that it's a service. And so a lot of that comes through that. And if they have to, if it gets, and I understand you're talking about, transition, but are some of the families that we work with. They don't want to do the special ed piece. And then we have a lot of families that have take their students out of school, but no, there is no funding under Section 504. So if anything, if we're going to access related services or what have you, then they have to find the money from someplace else to be able to pay for that. And that's why they'll move the kids over to special ed. But I know that in some most recent information that they're looking at changing the way that the funding is to give more money. And I forgot where I saw that document that's from OSPI. But currently, that even if they were only getting funded by the percentage of students in the district, that they had the access to safety net funding. And that would require individuals to open up their books to see how they're using their money to get that additional money. And so when you look at that whole thing over the years, I've only seen like maybe 1 or 2 school districts apply for safety net funding. And that was like Seattle. And then there was 1 other district. So
Right.
whatever students, once they, October is the month they get the percentage or whatever. So any students that moved in, whether you're military students moving into different districts across the state or whatever, it didn't change the amount of money. But they still have to provide. But I hear what you're saying. That's a good point in reference to our students under 504. But if they're connected with DVR services, things like that, if they meet that criteria, that's another way of looking at some sort of transitional support for them.
Are there any limits about which services can be provided to students virtually?
I mean, they were providing the services, for all students virtually, especially during the COVID. But then we had other students that it didn't meet their need, and so they were brought into the school. That's when they started opening up little spaces in the school district for those students to come in to get their special ed services. And so you already have it listed in his IEP where he was getting that one-on-one support. I mean, not one-on-one, getting the sensory in the way that's listed that caused him to have some benefit. And so right now, without that, he's not going to benefit from his services because they've removed that. So you still have the opportunity to ask for that, or they can contract outside of the school district for that. So because we know that things do change. People do change and what have you, but they're still obligated to those, find an agency for you to go to, because a couple years ago, districts went through that and they had to wind up sending the kids outside to other places because all of their OTs or speech and language individuals had left. And so that's that matrix page is very important. That's the service that, that matrix page, based on the evaluation and IEP goals and so forth, says that if we provide this, then the student's going to be able to meet this goal for the whole year, whichever goal, the goals that are listed as IEP, by providing that speech and language, by providing the OT, whatever. So,
are there supposed to be goals in the transition plan for students on an IEP?
Depends on what is, when they go through the assessments that they do, because actually the transition services don't have to be in place by age 16. And you've got some that will start it at 14 they'll continue on because, as you know, transition is always ever going. And you got one or two districts that start looking at that at 9 if the students are, willing, to look at that or to start that process. So, but so you look at the, the assessments, what those assessments that they are, finding out what the student wants to do and all of that, and that's put into the plan. And so if part of that outcome of that assessment is that they want to start, their schooling to go into a particular career, whatever, at the vocational school, as long as they have the 10 credits, they can do that. So there would be goals around that, and a lot of them are very blank, but yes, there can be goals around that. Can have that in there, but it depends on the team. If the families don't know, how to move forward with those, then you wind up with what you just described. And you're waiting for DVR to be at the table and they don't get there. So then what I'll do is go on the website to find out who the DVR representatives is for that high school area, and then get the family connected with them so they can bring them to the table and not, going back and forth to eliminate some of those steps for them. So there was a young man who had spina bifida, but he wanted to be a medical assistant. He had weak areas in writing and reading. He had 1 credit away from being able to graduate. They were going to try to graduate him, but this really nice transition specialist from the district froze his credit from the registrar's office, or however that goes, and she had goals written up in that area, allowed him to continue, finish with the school and go down to the vocational school to finish up. And I thought that was that was awesome. And that's what he's doing now.
Thank you for joining us for tonight's presentation. If you have questions, you can contact the ARC at 360-537-7000 or PAVE at 253-565-2266 or toll free 1-800-5-PARENT.